Good morning, everybody. This is Erik Daly. I'm a corporate attorney with Miller Johnson, and welcome to our May 13th, 2020 Coronavirus COVID-19 Response Team morning webinar. Today we will be talking about some considerations for Paycheck Protection Program borrowers in light of the currently scheduled deadline of May 14th, tomorrow, to potentially return PPP loan proceeds already received in light of shifting guidance from the Treasury Department and the Small Business Administration. So before we jump into the substance of today's presentation, we always like to start our morning webinars with a reminder of sort of our core principles as we proceed with working with clients in the community through the COVID-19 pandemic. And those core principles are really collaboration, candor, ingenuity, intellect, and creativity in coming up with solutions to help our community thrive, help our clients survive and thrive. And so that ties in well with today's presentation. Joining me today are my colleagues, Loic Dimithe, who is also a corporate attorney, and Laci Reséndiz, who is a litigation attorney at Miller Johnson. And we, together with some of our colleagues, are working on a cross-functional basis as we sort of move into this next phase of the PPP program to prepare clients for the possibility of a review by the SBA when documentation is submitted to request forgiveness of loan proceeds and or to make a decision prior to that to potentially return PPP loan proceeds. So before we jump into that, one last thing that we typically do at the beginning of our morning webinars is to do a bit of a roundup of some of the more material news items related to COVID-19. We'll do this quickly. Statistics related to worldwide cases, U.S. cases. It looks like there are about 4.25 million confirmed COVID-19 cases worldwide, with the number of deaths from that approaching 300,000. And of that, 1.4 million cases are in the U.S., with approximately 83,000 deaths. And then more locally here in Michigan, where we are, of the 1.4 million U.S. cases, about 48,000 of those confirmed cases are here in Michigan. And of the 83,000 deaths, about 4,600 are here in Michigan. I think those numbers in many states, at least in the U.S., are starting to level off. That is also the case in a number of the countries that dealt with this before it, really started to spread in the U.S. as well. Although there have been some outbreaks again in different places like Korea, South Korea, and elsewhere that have had to be contained. Setting that aside, just on the domestic front, legislatively, the Democratic leadership in the House unveiled a $3 trillion fourth phase COVID-19 relief package, and said they plan to take a vote on that this week. That would be the largest stimulus spending measure in U.S. history. And if it does move forward, it would set up a potential showdown with the Republican-controlled Senate, whose leadership has said that that would be premature and that another round of emergency stimulus funding is not yet necessary, although I think both parties acknowledge that ultimately some further round of funding or stimulus will be more a matter of when and not if. In Senate testimony yesterday, Dr. Fauci warned senators that there needs to be caution in moving things forward, as there could be and likely will be some local spikes and outbreaks as economies reopen, and that we need to be vigilant about being able to deal with those situations. And then last thing I'll note here, the California State University system, which is the nation's largest public university system, said yesterday that they were going to be canceling in-person instruction for all of their 23 campuses, and that instruction would take place almost exclusively online. So that's the news update for today. There's plenty of other news, but obviously we don't have time for all of that. We want to jump into our topic for today. So why don't we move forward with the slides? And I looked at the roster of attendees for today's webinar, and over the last 6 weeks, I think I've spoken with many of the attendees, and I think this title captures a lot of what folks are feeling in terms of bait and switch regarding how the program has been rolled out and sort of the shifting criteria for participation, the absence of guidance for forgiveness. And that's really the underlying sentiment for today's webinar is, in light of that changing guidance, what do we do? So that's what we'll focus on. And again, we're bringing this webinar together from a sort of a cross-functional corporate and litigation perspective to make sure, we're looking at the potential range of activities, consequences, and mitigation activities holistically. Let's keep moving ahead with the slides. Can read through this, our standard information about these slides in the webinar being for informational purposes. And although I know we have many clients on the line, if there are specific questions that you have, or if you're not a client but are interested in having an attorney-client relationship, we really need to have more individualized follow-up to do that, or to provide specific advice to any particular situation. So with that said, let's move on into the actual presentation. I think most people probably, I would guess 95% or more of the participants on today's webinar know what the Paycheck Protection Program is, at least at a high level, even if they don't know, understandably, what all the rules are. I'm not sure anybody really understands what all the rules are, given all the various guidance, but very, very high level, it's a small business loan program, and the loans can be wholly or partially forgiven, depending on how they are used, when they're spent, for what purposes. And the main forgivable uses of the loan, really the only forgivable uses of the loan, are payroll costs, rent, mortgage interest, and utility payments. The CARES Act itself did not impose a 75% spending requirement for payroll costs, but through rulemaking, the SBA and Treasury settled on a rule that at least 75% of the forgiveness amount sought and 75% of the overall loan proceeds must be spent on payroll costs. I'll just note anecdotally that there's news reporting about bipartisan support in Congress at some level. We'll see how much support to perhaps modify that rulemaking so that more of the funds could be spent on non-payroll costs, given the number of businesses in many states that are just not able to operate, with anything close to a full payroll unless they're paying employees to stay at home. So we'll see what happens on that front. There's nothing definitive to report there, but it looks like there is some bipartisan consensus developing that the original terms of the program may need to be modified in some ways to accommodate the realities that have played out over the last 6 or 7 weeks since the CARES Act was passed into law. The loans may be wholly or partially forgiven based on how they're used. We talked about that. And then the other two main criteria, assuming you're an eligible borrower for forgiveness, are, to what extent did you retain full-time equivalent employee levels, and to what extent did you keep wages more or less the same as they were in the first quarter or the previous quarter prior to receiving your loan, which I think for most people, will be the first quarter of this year, probably everybody, unless they extend the June 30th end date for the program. The program is available to businesses with 500 or fewer employees, although there are a number of exceptions to that, or other ways that a business could be eligible with more than 500 employees. So certain industries have higher employee thresholds. Some businesses can qualify based on their annual receipts over the last 3 years. Some may qualify as under alternative size standard, which looks at tangible net worth and taxable income. So there are a number of different ways to qualify. That has expanded eligibility for many legitimate small businesses. I think it's also, in some cases, opened the door to some companies that then resulted in political kind of pressure to swing the pendulum back from kind of broader participation in the program to more restrictive participation, and putting some pressure on some of those borrowers that maybe the public doesn't think of as a quote unquote small business to return funds, even though they satisfy the legal criteria under the program to be eligible borrowers. And that's been one of the undercurrents of everything that's happened over the last 5-6 weeks in terms of the evolving guidance and uncertainty. And then beyond small businesses, the program is also available to self-employed individuals, gig economy workers, and certain not-for-profits, as well as beyond 501c3s, certain hospitals and faith-based organizations that may not have obtained 501c3 status because they didn't need to in order to be tax-exempt entities, but would otherwise satisfy the criteria. So there are a number of exceptions to this 500 employee rule. Those are some of the noteworthy eligibility standards. And then lastly, maybe most importantly for this presentation, one of the key terms of the Paycheck Protection Program as originally enacted by Congress was that there is no credit elsewhere testing. Credit elsewhere testing in the SBA context it would typically mean, outside of this pandemic situation and the waiver of this requirement, would be that a borrower who would otherwise be seeking a loan backed by the SBA would need to show that it attempted to but was unable to obtain a loan or credit from another source. And so that credit elsewhere testing was waived under the CARES Act statute in many of the communications, as we'll get to on the next slide. It was emphasized that was waived as a requirement, but then you'll see here in parentheses, it was sort of waived, because subsequent guidance then brought back in the notion that, well, borrowers should consider whether they have other sources of capital or debt borrowing capacity. So let's keep moving. We'll talk about that more. So here's a quick rundown of the timeline of what's happened. And again, this sort of underscores some of the uncertainty that's played out over time. The March 27th date, that's when the CARES Act passed. Well, that's when the Senate approved what the House had already approved, and the President signed it into law the same day. And you can see here the language in the statute for this quote-unquote need certification, which was required to be made in good faith by eligible borrowers. And the standard, which still exists as a statutory matter, is that the uncertainty of economic conditions makes necessary the loan request to support the ongoing operations of the borrower. A couple things that I think are worth noting here, which are not necessarily on the slide, although one is noted here, is that the statute also included presumption that any eligible borrower has been negatively impacted by COVID-19. So that's one thing. And then another thing which is not noted on this slide, but which I think is important in keeping in mind when we're talking about what this statutory requirement for this good faith certification means, is that the original CARES Act said that these loans could be of a term of up to 10 years. It was only after the legislation passed and the SBA and Treasury began rulemaking that they imposed the uniform 2-year maturity across all of the PPP loans. And I mention that because if you think about a PPP loan if it's played out differently with a longer term time frame, as Congress had originally permitted or created the possibility for, it kind of changes your frame of reference or your time frame when you're thinking about economic uncertainty and making the loan request necessary to support ongoing operations. It changes your mind from thinking about, tomorrow or the next 8 weeks or the next, 2 years, potentially a much longer time frame. And I don't know that that aspect of this has gotten that much attention, but I think it's important to remember that this uncertainty standard and the need standard was paired with the concept that these loans could have been up for up to 10 years under the original act. So that may be an interesting facet of this going forward. And then on March 31st, the SBA and Treasury started putting out summary overview materials to kind of get the word out to small businesses who might not have otherwise, been contacted by their accountants or other advisors about the program. Some of the stuff they said there also, emphasizes that this is a broadly available program. They wanted all small businesses to be eligible, encouraging people to apply as quickly as possible because there's a funding cap. They didn't even mention the certification issue in the overview materials. And then April 3rd, there's an information sheet that's released, just kind of reiterates the need certification language of the statute. There's a specific question: do I need to first look for other funds before applying to the program? No, period. And this is where waiving the usual SBA requirement that you try to obtain some or all of the loan funds from other sources. That seems pretty clear. That's helpful early on. April 23rd comes around. This is after now some of the public company reporting about some of the public companies with larger operations that qualified for some of the affiliation exemptions that ended up with larger loan amounts, which, I have to say as an attorney, I think they were, I don't have all the inside information, obviously, they not clients, but they're probably well-advised borrowers and determined in good faith that they were technically eligible under the statute. And given the uncertainty around some of the certifications, proceeded on the basis that they were eligible. But public pressure to return the funds after reporting on this kind of prevailed in many cases, and some borrowers went ahead and returned the funds before this April 23rd FAQ. Others did it afterward, but I think, the SBA and Treasury said, given that a number of borrowers are considering this and we want to encourage this in cases where maybe it wasn't an essential lifeline for the business to continue, we want to create a clear pathway for borrowers to do that. So if they do return their funds at that time before May 7th, we'll deem their certification to have been made in good faith, so that we can't come back and say that the government can't come back and say that there was a bad faith certification made to get the loan. And the FAQ also, we'll get to it in more detail, but this is where there's now a shift to encouraging or requiring potentially businesses to look at other sources of liquidity, which is contrary to pretty much everything that was said prior to that. And then on April 28th, it was emphasized, it was clarified that, this guidance was not only applicable to kind of larger public companies, but also privately owned businesses, and really just about every borrower should evaluate their eligibility and their ability to, in good faith, make the need certification based on the standards that were laid out in that FAQ number 31. And then also, and kind of in tandem with that, the Treasury Secretary announced, and then this was memorialized in FAQs and guidance, that the SBA would be reviewing all loans, forgiveness requests for all loans in excess of $2 million. So we would have thought that by today we would have another little arrow here with some bullet points underneath it, because on May 5th, the SBA extended the good faith loan return deadline to May 14th, which is tomorrow, and said that they would be issuing additional guidance on how they would be interpreting the need certification from borrowers. We haven't, unless it's come out since this webinar started, we haven't seen that yet. So we don't have another arrow here to talk about what that guidance may or may not be. We'll see if that comes out today, or if it doesn't, if the deadline gets moved again. But this is where we are now. May 14th is the deadline. That's tomorrow. And it looks like unless the date moves, there's going to be some pressure to make quick decisions based on whatever guidance does come out. So let's keep moving. So this is the FAQ number 31, which sparked a lot of the uncertainty from borrowers. And you can see without reading the full thing here, the key points are the SBA is reminding all borrowers to assess these criteria, and to distill it down to really two concepts, which I think is helpful just in a summary fashion, is one, what is the economic uncertainty? What is the business activity negative impact that is justifying the need for the loan? That's kind of the first prong of the inquiry as we think about it. And then secondly, and then again, this runs contrary to the no credit elsewhere testing, what other capital and liquidity might be available to the business in potentially supporting their ongoing operations, and most specifically payroll, in a manner that is not significantly detrimental to the business. So a lot of ambiguity around that, good questions asked about what that really means. Does that mean that somebody has to, that a business needs to exhaust all existing lines of credit? They have to use most or all of the cash that might be on their balance sheet? If it's a privately owned business, does this mean that an owner or group of owners need to, put additional equity capital into the business? And there's really no, because we haven't gotten the guidance yet, And even if we do get the guidance, it may not be addressed. There's really no answers to those questions other than this is something that a borrower should consider in good faith. And in our advice, which we'll get to later, have a good contemporaneous record of having considered that and considered what, if any, significant detrimental impacts there would be from doing those things. So let's keep moving. And then I think we've touched on this already, but yeah, the guidance on what is, how to evaluate this necessity certification has not yet been issued. But there's some speculation here based on updates from relevant players. Senator Rubio has been very outspoken kind of about what the Senate's intent was with respect to this bill. I don't think that's necessarily controlling, but he's been one of the more vocal senators, and he's the chairman of the Senate's Committee on Small Business and Entrepreneurship. So there may be some weight placed on what he has to say, but he's just one person, and this is a very complex program. So I wouldn't view his statements as necessarily the final word on any of this. And then we touched on this last bullet point. A borrower currently has until tomorrow to return their funds if they believe their certification was not valid, or if they misapplied the criteria as later quote unquote clarified by the SBA in its subsequent guidance. So that's sort of where we are now, unless the SBA has issued something further while we've been on the webinar. And with that, I'm going to turn over the webinar to Loic, who will talk about some of the other agenda items for today and kind of what the path forward looks like.
Thanks, Erik, and thanks everyone for joining us this morning. With that, with that background, we turn to what we really want to highlight for you guys today is really just providing some insight on the SBA and the Treasury's authority to audit and what we know and what we think that audit process will look like. Potential fines and penalties that a borrower may face following these audits, and then really just provide some best practices for preparing for and ultimately responding to that audit process in case following the audit you get an unfavorable review. So, there's been a lot of just governmental action lately relating to the stay-at-home actions and PPP and the guidance that has come out. And the first threshold question that a lot of clients have been asking is where the authority comes from to enforce some of these potential fines and penalties. And really, for purposes of this, the audit here really comes from, the Special Inspector General for Pandemic Recovery in Section 15010 of the CARES Act, which creates the Pandemic Response Accountability Committee, which is ultimately tasked with preventing and detecting fraud, waste, and abuse of the program collectively. That committee has the ability and the power to subpoena borrowers as part of their audit process in order to request information, speak with individuals that they believe would be relevant for purposes of their inquiry. This authority includes really the ability to interview individuals, request documentation, request for written affidavits from individuals who they believe may have relevant information, really provide potentially a very thorough, exhaustive review of the business of the borrower and their ultimate need for the loan funds. What do we know about the actual audit itself? Right now, we don't know very much. Still waiting on further guidance on what that audit process will really look like in terms of timing, what borrowers can expect. What we do suspect that they'll probably focus on are factors outlined here in the slide. The size of the business, the business's actual needs for funds, whether the funds were used for preventive purposes or forgivable purposes, and whether employees and compensation levels were maintained per the loan forgiveness guidelines. Other than that, at this point, we're still waiting on further guidance on what exactly this process will look like, other than the fact that we anticipate all loans in excess of $2 million will be audited, and we do have the May 14th deadline so far, and we hope to get further guidance, and to the extent anything changes, we'll obviously have to respond and adapt. As far as penalties, the question then becomes, if one does, following the audit, if they do receive an unfavorable review, what exactly can happen? What potential penalties, fines may potential borrowers be facing? And there's a few avenues that the SBA, the Treasury, and the government may pursue, but we did want to highlight just a few of them for you, some of the bigger ticket items outlined here, starting with the false statement on an SBA loan application. Really, the standard here is liability stems from both knowing and willful misrepresentation during the application process. Potential fines of not more than $1 million, and potential imprisonment of no more than 30 years. There's also the potential for wire or mail fraud claims. Here, the government must show that the defendant took part in a scheme that used electronic interstate communications or use of mail to further the scheme to defraud the victim or property. Potential fine here is not more than $250,000 and potential imprisonment of 20 years. The last one we really wanted to bring to your attention was potential liability under the Civil Liability under False Claims Act, which requires establishing that one knowingly presented or caused to be presented a false claim for payment from the government. Here, knowingly is established as being having actual knowledge or acting in deliberate ignorance or reckless disregard for the truth or falsity of information. Potential penalties includes 3 times the actual amount of its damages, which, in this context will likely be the amount of a loan, plus other ancillary penalties and fines ranging from $11,000 to $23,000 and some change. So what we really wanted to highlight for you guys here is that although these are quite hefty fines and penalties, we want to bring your attention to the component that they established that one knowingly and willfully was working to deceive or mislead the government as part of their application, as part of their belief as to whether the funds were necessary. And we think that most borrowers will greatly exceed that threshold and won't really face any potential liability under that standard. But the biggest question mark and the biggest source of anxiety really comes with borrowers who, in good faith, believe that they qualified and were eligible for the funds given the information that was available when they applied for the funds, and what liability can they face in that instance. And that, so far, is unclear and unknown. What will likely, at a minimum, borrowers that do receive an unfavorable review following their audit, to the extent that they did apply in good faith, what they will likely experience is that they will not receive forgiveness on the loan, which obviously has various business and legal implications of having an additional layer of indebtedness on the books, and how that interacts with other debt that the borrowers may have, or other covenants or agreements that the borrowers may have with their other lenders, creditors, stakeholders, etc. And with that, I turn it over to my colleague Laci to discuss some of the most recent enforcement actions and some practical advice on preparing for and responding to potential audit.
Thank you, Loic. As you can see on here, there has been one major enforcement action under the PPP, And that was 2 men out of Rhode Island and Massachusetts that were charged with conspiring to seek forgivable loans guaranteed by the SBA. They were claiming to have dozens of employees at different business entities when, in fact, there were no employees because the restaurants had been shut down before they had applied for the loans. And so again, all the penalties and fines that we showed you on the previous slides look very steep. Those are dependent on a willful or knowing intent to deceive and mislead the government. Next slide, please. As Loic mentioned, you want to be looking at enforcement actions, but also being able to get the loans forgiven, because that's one of the biggest business implications here. So we've put together some best practices to prepare for enforcement or other actions, which could include review of the forgivable amount of the loan. First, we recommend that businesses evaluate and document economic impact. So determining how the business was doing before the crisis, what concerns existed at that time, what at that time were foreseeable detriments of the COVID-19 virus and the impact on the business, and seeing how much of that has come to fruition. That includes analyzing annual and quarterly budgets, projections, other key performance indicators. You also want to evaluate and document your assessment of other options. While there is a strong argument that if you received the PPP before FAQ 31 came out, that you didn't have to look at other sources of liquidity, to the extent that a business can satisfy multiple standards, the evolving standards, that is beneficial to the business. So document what available cash or debt capacity the business had, what, going back to the whole purpose of the PPP, is keeping workers paid. Without the PPP, would you have been looking at laying off workers or decreasing compensation? And keeping those thorough records of your loan applications and any related information. And particularly based on FAQ 39, if you have a loan greater than $2 million, the SBA and Treasury has already guaranteed that they will review those. And this is best practices, though, for businesses even that received lower loans. Next slide, please. And of course, take note of impending deadlines for forgiveness applications, respond accordingly, ask for extensions where necessary, and importantly, coordinate with your response team. So work with your advisors, that includes your legal counsel, tax advisors, accountants. Miller Johnson, working as a joint venture between our corporate side and our litigation side, are putting together a service offering for PPP enforcement and audit preparedness. So it's where you'll get eyes on your documentation from both the business side and the litigation side. The business can help you identify the documents and key performance indicators that you had available to you when making certifications, and then litigation can look at how and to what extent those indicators and that documentation supports your certification under the different standards, and putting that together so that you are prepared for any further action. And it is important to note, I'm not sure if it came up earlier, but while there is the safe harbor provision for returning the loan in full by, as of right now, the deadline is tomorrow. I did refresh guidance and I haven't seen anything as of 8:30. Deadline's tomorrow. All that guarantees is that the need certification will be deemed in good faith. There is no additional guarantees if you return the loan by tomorrow. So if there was a false statement in the application, there's no guarantee that just returning the loan kind of erases that liability or exposure. The only guarantee that safe harbor provision provides is that one certification will be deemed in good faith. And of course, from the litigation side, assert applicable defenses. So argue against enforceability of the new and more stringent necessity standard and the retroactive effect of that the SBA and the Treasury alluded to in FAQ 31, and prepare other defenses as applicable. And with that, I'll turn it back to Erik and Loic to start talking over questions.
Yeah, thanks, Laci. I've been, this is Erik speaking. I've been answering a few of the questions in the Q&A box by typing responses. I'll answer some more and open it up to the full group of the three of us to provide answers on some of these. A couple of these are pretty straightforward. One, are benefits included in the payroll cost 75% of loan calculation? Yes. Employee benefits are payroll costs that would count towards satisfying those 75% criteria or thresholds for spending. So it's take one of the easier ones first that we think we know the answer to, but no, on that one, I believe we have good clarity on that one. Here's another kind of more open-ended one, which I'd be curious. I think we're speculating to some extent here, but let's do that and talk a little bit about it. But the question is, in an audit, if we still opted to lay off employees and reduce some salaries, will this be viewed in a negative light in the audit? Does this create an issue? I'll answer on the corporate side, and then Loic and Laci, you can weigh in too. I think this potentially cuts both ways, right? Because on the one hand, in the application for the loan, borrowers certify that they're going to use loan proceeds to fund payroll costs, pay employee expenses and the like. But on the other hand, if you got a PPP loan and you still determined that you need to lay off some employees or reduce salaries, I think that could argue in favor of, boy, there really was, even with the PPP loan, there's an economic negative impact that resulted in some layoffs and reductions in salaries. And so maybe even with the PPP loan, this business is, not in a situation where, it's able to continue to keep people on payroll. So I think that one, or on payroll at the same levels, I think that one kind of cuts both ways, and it will probably depend upon the context in which those layoffs were made or the salary reductions were made. But just as a statutory matter, there's no requirement that that you retain all of your employees, or you retain compensation levels at 100% of where you started. In fact, the Act expressly contemplates, that there could be reductions, and those reductions would result in a reduction in loan forgiveness, but it wouldn't make you ineligible for the program. So that's my view on it, is that it wouldn't disqualify you necessarily, depending on the other facts, but it may actually, in an odd way, support the fact that you needed a loan. Laci or Loic, I don't know if you have a different view on that one.
Yeah, the only other thing that I would add, Erik, is just from a practical perspective, when you do experience, headcount cuts and pay cuts, you also reduce the amount of eligible payroll that you have to use for the loan, which could then run the risk of you falling below that 75% required use threshold. And so, generally we want to encourage you to the maximum extent permit possible to fall within the known guidelines. We know there's a lot of unknowns but keep in mind everything that we do know, and if keeping folks on payroll, even if they're not necessarily doing any work, is what's required to meet that 75% requirement, then that may be something that the business may want to consider.
Yeah, good point, Loic. Laci, here's one that may be for you, and again, some of this is speculative because we are kind of in the early days here of the next phase of the PPP. But the question is, in arguing defenses, who exactly are we arguing with? Is there an appeal process? Could you talk a little bit about what that might look like?
Yeah. So it depends on where the enforcement action or other action is coming from. So to the extent, like for the enforcement action that you saw, that's the very egregious businesses in Rhode Island and Massachusetts, that would be coming from DOJ. If you're talking about trying the loan forgiveness application, that would be arguing against the SBA and Treasury if they're trying to apply a later standard to an earlier certification. So it depends on what angle it's coming from. And so it's just being prepared from all of those angles.
Okay, thanks, Laci. Just typing an answer to another question here. Another question, if we have projected out our expenses and see we may have a surplus, and this is a question that some people are getting or are envisioning, just because at the time that they made their application, they didn't necessarily have visibility. There was a lot of uncertainty, and then things play out differently, sometimes worse, sometimes better. So here's the question. If we have projected out our expenses and we see we may have a surplus, would you recommend returning the loan before May 14th? Is it okay to keep it in case we end up with unforeseen expenses? Will I get penalized if we have a surplus and return it after 8 weeks? I don't think we can provide, or anybody can provide, definitive answers to, or even really close to definitive answers to any of those questions. And I'm not scoffing at the question. I think it's a good one. I'm reacting this way just because of the absence of really some of the most important guidance that borrowers need right now and the uncertainty it creates. I mean, these are great questions, but we just don't have answers to them, right? We have answers to some very esoteric questions in the FAQs, which I can't imagine are really that frequently asked, but we don't have answers to some of these types of questions. So if you'll excuse my venting there for a moment, the question I would say is, if you have a record of your certification being made at a time when you were projecting that you needed the loan, the time you made the certification is the most important time frame. Things will shift and evolve, as circumstances do. It could be better in some cases, could be worse in others. For some borrowers, it could get better and then worse again if there's an outbreak. So I think for a situation like that, it's important to remember that kind of the key principles here are the uncertainty of the COVID-19 pandemic, which I would recommend not be viewed as you're creating your record as just sort of a one-time event, and viewed more as and this aligns with, I think, all the objective scientific, what's being advised by public health experts is that there are likely to be peaks and valleys and future outbreaks, and kind of think about it in that context. So even if you're projecting something right now, is there still uncertainty going ahead, and creating a document of why you think that might be the case. On the question of can you keep it if there are unforeseen expenses, the loans are for up to 2 years as currently implemented by Treasury. Assuming you determine you're going to keep the funds past May 14th, you can keep the funds past the 8-week forgiveness period, but expenses after that 8 weeks are not forgivable, so they need to be repaid. They still do need to be permitted uses of funds under the PPP, and you still do need to, at least under the current guidance, spend at least 75% of it on payroll costs, but you could keep the loan outstanding for up to 2 years at 1% interest. You just need to make sure you still comply with the program rules. It's not as though at that point the loan kind of turns into an all-purpose or a general purpose unsecured loan. Are you aware of any enforcement actions locally? If so, well, no, we're not aware of any enforcement actions locally. Loic or Laci, you can weigh in if you're aware of anything that didn't show up on our searches or on my radar.
Nothing has come up.
Nope, we are tracking all of the PPP enforcement news, but nothing has come up locally.
Yeah, right. I think we're aware of some handful, not a lot. I don't think this is a title waiver or anything like that, but we're aware of some Michigan borrowers who have returned PPP loans, but no enforcement actions that we're aware of locally. And those are really ones that have been publicly announced returns of PPP loans. I'm not talking about anything confidential. You can look in the news for the Michigan borrowers who have made that decision. We had laid off staff prior to applying for the loan, our thinking being that the loan would allow us to put them back on payroll. Should we be concerned about that? My view is no. I think that unless I'm missing something, prior to applying for the loan, you made a determination that you had to lay staff off, and only with the PPP loan could you put them back on staff. I think that all aligns with, we don't have all the facts here, but I think that generally aligns with what the policy of the program is really, the public policy really is. I don't know, Loic or Laci, if you have a different view on that one. But no, I think that's kind of exactly what this program is for.
Yeah, I agree. I think that's pretty consistent with what the intent is here.
Yeah.
Has there been any clarity on cash versus accrual basis accounting or, kind of determining for that 8-week period, whether you're talking about just cash outflows versus determining forgivable expenses on an accrual basis? There has not been any guidance provided. So all we still have is just the language in the statute itself, which I don't have right in front of me, but I believe it's, Loic will maybe help me if I get this wrong, but I think it's amounts paid and costs incurred is the language. And so that's created the uncertainty about whether borrowers should be just looking at just cash that goes out the door during that 8-week period, or some combination of accrued amounts and cash going out the door, or being able to use accrued amounts. So that has not been addressed. And, that reminds me, I'd meant to touch on this in the beginning of the presentation, but prior to all this uncertainty around the need certification, the major thing that borrowers were waiting on the SBA for was kind of more comprehensive guidance on forgiveness related issues. And it's noteworthy that also has not arrived yet. I think that's taken a back burner to this more threshold question about need. So, kind of the bookends of this process, the threshold question of, am I eligible based on need? That is uncertain because of the absence of guidance. And then on the back end, the other bookend of this is the forgiveness question. That also remains uncertain. So, no, there's been no further clarity on that issue. Sorry, there was a question. Maybe it was just answered because it disappeared from my screen. Let me find another kind of generally applicable question here. I don't know if we have the answer to this question, Laci or Loic, but there's a question about with regards to that one enforcement action in Rhode Island and Massachusetts with the restaurant businesses. The question was that shut down in response to COVID-19 like many were, or was it shut down prior to COVID? I'm going based on my recollection of the reporting at the time, but I think part of the issue was that the restaurants didn't exist yet at the time. You got to look to see that the business existed at February 15th. So I'm not sure that it's even an issue of whether it was operating or not. I just think there was some pretty, allegedly there was some pretty significant fraud just as to whether the business even existed as of the right time.
Yeah, so the news that has come out about it says that the businesses were not operating prior to the pandemic. It had nothing to do with the pandemic. And I believe one of the restaurants in question was shut down for an issue with a liquor license.
Right.
So it was not.
Yeah.
It was not
pandemic-related
closure.
Right. Yeah, there was a closure for another reason, and then in a couple of cases, one of the requirements for being a PPP eligible borrower is that your business existed as of February 15th, and I think at least in one or two of those restaurant cases, it didn't exist. So those were more egregious issues, not really related to executive order type shutdowns. Is there any indication if the forgiven portion of the loan will be considered taxable income? The Act is very clear that the answer to that is no, at least for federal tax purposes, although the IRS, because of that, put out a notice saying that forgiven expenses will not be deductible for tax purposes either. Some Congress people have pushed back on that, and so while the IRS has issued a notice to that effect, that may be something that changes based on future legislation, is both allowing the forgiveness without considering taxable income resulting from that, as well as permitting the forgiven expenses to be deducted. But right now, the expenses would not be deductible to the extent of the forgiveness, because the forgiveness would not be taxable. Here's a good question. I mean, these are all good questions, but this is an open-ended one that I think lends itself well to input from Loic and Laci as well. Can you describe the risk window here? When do we expect the forgiveness decisions to be made? Is there a statute of limitations guidance to SBA as to how far out they can challenge the loan provided? Let me just answer part of that and then turn it over to Laci. Forgiveness decisions need to be made under the statute, and SBA has shown they're not unwilling to deviate from the statute. But going by the statute, 60 days after the submission for the forgiveness request is made is when the bank is envisioned by the statute to be your lender bank, the party making the forgiveness determination. Now, under this new guidance with the review or audit of loans, it could be in consultation with SBA. So that's when the decision would otherwise be made. We'll see if it gets pushed out based on some of the other things going on with reviews. But Laci, could you talk a little bit about the other kind of the open-endedness and the potential? Yeah.
Yeah, so for the more, I guess, egregious enforcement actions, so the criminally false statements that have the very steep penalties, those have statute of limitation up to 10 years. False Claim Act is a little bit shorter. It's 3 years unless it's not an easily discoverable false claim, and then it can be up to 6 years after it's discovered, but no later than 10 years. So the easier answer to it is the longest statute of limitations is 10 years, and the shortest is 3 years.
So pretty open-ended. Pretty open-ended.
But again, those have those standards of willful or knowing false statements.
Right. All right, we're bumping up against the 9 o'clock time frame. There's some other good questions. I'm going to try to do one or two more of these. Others, you should feel free. I'm sorry if some of the questions that have been submitted are fairly fact specific, and so we may not take those right now. I'm trying to address some more generally applicable ones. But you should obviously feel free to follow up with any of us afterward. Okay, here's a question that we've gotten from quite a few clients, and I think is generally applicable. Can I pay employees more than what they were making to use up to 75% payroll and therefore be able to use all of the 25% of ongoing rent and utilities? Again, it's a statutory matter. There's nothing other than the $100,000 annualized cap per employee on cash compensation. As long as you're paying wages, salaries, commissions, things like that, bonuses are not referenced in payroll cost definitions. So I wouldn't pay quote unquote bonuses to people, but I think you can pay, for example, hazard pay, and many borrowers are, under the statute. It's not restricted. I think that would align with the overall policy purpose here of keeping employees on payroll, making sure the funds go toward employee expenses, and not jeopardize your forgiveness. So it's not prohibited by the statute or any of the guidance. It's also not specifically permitted by any of the guidance, but I do know a lot of borrowers are paying hazard pay, for example, to employees in order, well, one, just because in many cases they feel that that's appropriate in light of the health risks, but also, then that goes toward the payroll cost calculation. What if you retained and paid employees not needed with the intent of funding those costs with PPP? That I don't personally see any issue with that, other than I'm not sure. The question is, does that then create an inequity if you're later determined not to have needed the PPP loan? It's hard to answer that question definitively. There's nothing, again, nothing in the statute that says you can't retain and pay employees that you otherwise might not have needed because you're using the PPP funds. In fact, I would think many people would say that's generally what the program was set up for, is to create a bridge from the onset of the pandemic to the quote unquote new normal, so you can keep these employees on your payroll and not have to terminate and potentially rehire them. But it probably, I'm not sure if there's more to this question that I'm missing that is concerning. But in general, it would be fine to use PPP loans for that purpose. Any other questions, Loic or Laci, that you see? I want to be cognizant of time here that you'd like to address before we sign off. I know there are a number of open questions here. Some of them are pretty fact specific.
No, I don't really see anything else that comes up on my mind, Erik.
Oh, here's one that I'll just address real quickly. There's a question about what if what should you do if you receive money from PPP, but your business has not been allowed to go back to work yet? Can we use it for other costs to maintain our business not listed, like liquor liability insurance, or should this money be returned? We can use it for payroll as soon as they allow us to go back to work, but more than likely it will not be 75% because of the time range of 8 weeks from date of receiving the money. So there are only certain permitted uses of PPP loans. And so it's important if you don't return the money, and regardless of whether you're talking about the 8-week period or after that, that you're not spending PPP loan funds on impermissible uses, and that you're still complying with the 75% payroll cost threshold requirement. So you can use them for non-payroll costs, but it's important to keep in mind that 25-75% split, and to make sure that the 25% that's non-payroll is still a permissible use of PPP loan funds, which are generally things like employee-related compensation. You can pay interest on other debt, utilities, mortgage interest payments. There's a handful of other things, but it's not totally open-ended. Laci, is there anything else that you wanted to address from the Q&A?
Not being cognizant of time, I don't think we can go through the rest of them. Okay.
Well, and again, if, we're happy to, of course, consult with people, and we imagine we will be doing quite a bit of that in the coming weeks and maybe longer on some of these specific questions for clients, and just helping make sure that there is a kind of a good record to support your keeping the loan funds if that's what your business opts to do. If not, helping you decide, why you would return the funds in the short time frame unless the deadline gets extended again. So do please feel free to reach out to us. We'll be sending out a client alert, I'm sure, with additional information about, any further SBA guidance, as well as, the Miller-Johnson litigation and corporate joint group that's going to be working with clients to make sure that they're ready for the next phase of this, specifically the review of the audit review and the forgiveness phase of this. So thank you very much for attending. Yes, Loic.
One last thing. I think we are supposed to mention, in addition to our audit preparedness kit, the Miller-Johnson Back to Work Resource Center. Just want to make sure that people are aware that this resource is available to assist people who are revving up and need guidance on ensuring that they're providing a safe workplace in the process of opening up and continuing to operate. That resource is available, and we encourage you guys to reach out to get further information.
Thank you, Loic. Well, that's all we have for today. Thank you again for spending some of your morning with us. We hope you have a good day. Everybody staying healthy, and we'll continue to keep folks updated through our client alerts and webinars going forward on these topics. So appreciate you joining us, Loic and Laci. Thank you so much for your work on this, and hope all have a great day. Take care.
Bye-bye. Thank you, everyone.
Bye.